Something just shifted in the fight over magazine bans and rifle restrictions in America, and honestly, most people have no idea how significant this moment actually is. A brand new court ruling just landed, and the plaintiffs in one of the most important Second Amendment cases in the country immediately weaponized it. They filed a supplemental brief, essentially telling a powerful federal appeals court, "Look at what just happened. You need to rule the same way. And here is why this matters to every single gun owner in this country." This case is now positioned to create the exact legal collision that the highest court in the land has been quietly waiting for before it steps in. If this goes the way many legal analysts believe it could, we are looking at the beginning of the end for magazine bans and potentially rifle bans across multiple states. So let me walk you through exactly what happened, why it matters, and what comes next. Let me set the stage so everyone is on the same page, regardless of how closely you have been following this. There is a major legal challenge working its way through the federal courts right now that takes aim at New Jersey's ban on so-called assault weapons and their restriction on magazines holding more than 10 rounds. This is not some minor procedural skirmish. This case has already escalated to an extraordinary level. The Third Circuit Court of Appeals, which is the federal appeals court covering New Jersey, took the highly unusual step of going en banc in this case. For those unfamiliar with the term, en banc means the full panel of judges on the court decided to hear this case collectively rather than leaving it to a standard 3-judge panel. Courts do not take that step lightly. It signals that the judges themselves recognize this case raises issues of exceptional importance, issues where the outcome could reshape the legal landscape. On top of that, the current Department of Justice stepped into this fight on the side of the plaintiffs. Think about that for a moment. The federal government actively told the court that New Jersey's ban on certain rifles and magazines needs to be struck down. That is not a small thing. When the DOJ weighs in on a case like this, it carries enormous persuasive weight with the judges. Oral arguments have already taken place, and from all accounts, the judges on the en banc panel were visibly divided on the core legal questions at play. Some seem sympathetic to the argument that these bans violate the Second Amendment. Others seemed inclined to uphold them. That division itself is significant because it tells us this case is genuinely up for grabs, and the outcome could tip in either direction. Now here is where the new development comes in, and this is the part that changes the calculus dramatically. On March 5th, a separate court issued a landmark ruling in a case challenging Washington D.C.'s ban on magazines holding more than 10 rounds. That court, the D.C. Court of Appeals, struck down the ban. They did not do it on some narrow technicality or procedural ground. They went straight at the core constitutional questions and answered them decisively, and the reasoning they used is directly relevant to the New Jersey case that is currently sitting in front of the Third Circuit en banc panel. The D.C. court held 3 things that matter enormously here. First, they held that magazines of all capacities are unquestionably arms protected by the Second Amendment, not accessories, not peripheral equipment, arms. That distinction is critical because one of the arguments states have been using to defend magazine bans is the claim that magazines are merely accessories to firearms and therefore fall outside the scope of what the Second Amendment actually protects. The D.C. court rejected that framing entirely. They said magazines facilitate the use of arms for self-defense, and that makes them arms, period. Second, the D.C. court addressed the question of common use head-on. Under existing constitutional framework established by the highest court, the government generally cannot ban arms that are in common use by law-abiding citizens for lawful purposes. The D.C. court looked at the evidence and concluded that magazines holding more than 10 rounds are not just common. They use the word ubiquitous. They are among the most widely owned items in the country. Millions upon millions of Americans own them. They come standard with the vast majority of handguns and rifles sold in the United States. Under any reasonable interpretation of what common use means, these magazines qualify overwhelmingly, and once something is established as being in common use, the constitutional protection kicks in with tremendous force. Third, and this is where it gets really interesting from a legal strategy perspective, the D.C. court dismantled the historical arguments that defenders of magazine bans have been relying on. Under the framework that the highest court established, when the government wants to regulate arms, it has to show that the regulation is consistent with the nation's historical tradition of firearms regulation. States defending magazine bans have pointed to things like old Bowie knife restrictions, gunpowder storage laws, and various colonial-era regulations as supposed historical analogs that justify modern bans. The D.C. court looked at all of those arguments and said no. None of those historical regulations involved outright bans on commonly owned arms. They involved restrictions on how arms could be carried or stored in certain contexts. There is a massive constitutional difference between regulating the manner of use and imposing a categorical ban on possession of items that millions of people lawfully own. The Constitution does not permit the government to take historical regulations that merely restricted certain uses and then stretch them into justification for a complete modern prohibition. That reasoning, if adopted by other courts, essentially pulls the rug out from under the primary legal defense that every state with a magazine ban has been relying on. So now the plaintiffs in the New Jersey case saw this ruling come down and immediately recognized its significance. They filed a supplemental brief with the Third Circuit en banc panel specifically to bring this new decision to the court's attention. The message in that brief is straightforward. Another federal appellate court just addressed the exact same legal questions you are grappling with, and they struck down the ban. The reasoning applies directly to New Jersey's restrictions. You should reach the same conclusion. The timing of this could not be more impactful. Remember, the Third Circuit has already heard oral arguments. The judges are already deliberating. They are already working through the legal questions. And now, right in the middle of that process, a well-reasoned appellate decision lands on their desk that directly addresses the issues they are wrestling with. During oral arguments, the judges were clearly divided on whether the common use doctrine should be dispositive, meaning whether the fact that these items are commonly owned should essentially end the analysis in favor of striking down the ban. They were divided on whether magazines qualify as protected arms. They were divided on whether the historical analogs presented by New Jersey actually justify these modern restrictions. The D.C. ruling provides clear, well-articulated answers to every single one of those questions, and it provides those answers in a way that favors striking down the bans. Now let me explain why this extends far beyond New Jersey, because this is the part that affects gun owners nationwide. There are multiple federal circuit courts across the country that have addressed or are currently addressing magazine ban challenges. The Ninth Circuit, which covers the West Coast, has upheld magazine bans. The Seventh Circuit, which covers the Midwest, has leaned in a similar direction and appears likely to uphold restrictions in cases currently before it. But now you have the D.C. Court of Appeals going the opposite direction and striking down a magazine ban. That is how a circuit split begins to form. A circuit split occurs when different federal appeals courts reach contradictory conclusions on the same legal question, and circuit splits are one of the primary triggers that compel the highest court in the country to finally take up an issue and resolve the disagreement. Here is where the Third Circuit's ruling becomes absolutely pivotal. If the Third Circuit en banc panel follows the reasoning of the D.C. ruling and strikes down New Jersey's magazine ban, that would create a clear and undeniable circuit split. You would have major federal appeals courts on opposite sides of this question with no way to reconcile the conflict except at the highest level. The highest court would essentially be forced to step in because allowing contradictory rulings to stand means that the constitutional rights of Americans would depend entirely on which state they happen to live in. That is precisely the kind of situation the court exists to resolve. And consider this additional pressure point. Even if the highest court declined to review the case after the Third Circuit struck down New Jersey's ban, the practical effect would be that the ban is gone. It would be struck down and remain struck down. So either way, a favorable ruling from the Third Circuit is a massive win. It either directly eliminates New Jersey's restrictions or it forces a national resolution of the issue. Based on everything that has happened so far, including the oral arguments, the DOJ's support for the plaintiffs, and now the supplemental brief highlighting the D.C. ruling, there is a genuinely strong possibility that the Third Circuit could issue a ruling striking down at least some of New Jersey's restrictions. Many legal observers believe the most likely outcome, if the plaintiffs prevail, would be a somewhat narrow ruling focused specifically on commonly owned rifles and standard capacity magazines. But even a narrow ruling striking down those particular bans would be historic. It would be the first time a major en banc federal appeals court struck down an assault weapons ban or a magazine capacity restriction of this nature, and it would create that crucial circuit split that opens the door to a final nationwide resolution. The legal landscape on this issue has been building pressure for years. Multiple challenges have been working through the courts. The constitutional framework for analyzing these cases was clarified and strengthened in recent years. The federal government has now weighed in on the side of gun owners, and a fresh appellate ruling just handed the plaintiffs exactly the kind of legal ammunition they needed at exactly the right moment. The Third Circuit en banc panel is now the focal point. They have heard the arguments, they have the briefs, they have the DOJ's position, and now they have a brand new appellate decision from another jurisdiction telling them that magazine bans cannot survive constitutional scrutiny. All of those factors converge to make this one of the most consequential pending decisions in Second Amendment law. Once the Third Circuit rules, the only remaining step would be potential review by the highest court in the country. There is no intermediate step left. This is the final stage at the circuit level. So what we are watching unfold right now is not just another court case in a long line of court cases. This is a potential inflection point, the kind of moment where the legal trajectory of an entire category of constitutional rights can shift. The D.C. ruling changed the dynamics. The supplemental brief put it directly in front of the judges who matter most right now, and the stage is set for a ruling that could echo across every state with similar restrictions on the books. As this continues to develop, the key thing to watch is the Third Circuit's decision, and specifically how they address the common use question, whether they treat magazines as protected arms, and whether they accept or reject the historical arguments New Jersey has put forward. Those three questions will determine not just the fate of New Jersey's laws, but potentially the trajectory of this issue across the entire country. This is one of those moments where a single ruling has the potential to reshape the legal landscape in ways that affect millions of people. And all eyes should be on this court as they prepare to issue what could be one of the most significant Second Amendment decisions in years. That's it for today, folks. See you in the next video.